Okay, I'm Matt Lehman, State Representative from the state of Indiana, Cole past president, moderating this general session this morning, and it's exciting to do as we have a great panel of speakers today on a very interesting topic, third-party litigation financing. So third-party litigation financing, also known as litigation financing or lawsuit lending, refers broadly to the practice of providing money to parties to pursue a potential or a filed lawsuit in return for a share of the damages awarded or a settlement. Funding generally falls into two categories. We've had consumer funding for some time. We're seeing a growth in commercial funding. Commercial arrangements typically between funders, corporate litigants, law firms involving commercial claims, breach of contract, etc. Consumer agreements are typically your funder and the individual person, helping Aunt Martha, pay her bills, and then those around a lot of personal injury cases. So, if you're wondering, again, the topic of insurance, the issue has become as they're growing. There's no free lunch, so to speak, as this has grown. Evidence indicates that for end results of this capital infusion into litigation, industry, insurers, policyholders ultimately bear the brunt of the tab. And so with that, we are here today, and many times those funding terms are not, they're in the contract. We've always talked about transparency for the consumer, and that's what we're going to talk about here today, because sometimes those individuals may not even be aware of those issues. There are some definite benefits between litigation funding. It does expand access to the courts. We all can agree litigation should not be for only those who have means. It should be accessible for everyone. We'll have that discussion as well. The litigation funding industry has grown significantly in recent years, resulting in many states enacting laws to regulate the industry and protect consumers. Starting on page 310 in your binder, you can see the entire Indiana Litigation Financing Code. And on page 316 is the legislation that I sponsored this year to add essentially another layer of transparency. Several years ago, involved in Cole here, and we started the process of trying to develop a litigation funding model law with my very good friend and colleague, Senator Neil Breslin, on opposite sides of this issue. We spent multiple times in some very contentious meetings, and ultimately nothing could be agreed upon, and the issue died. And that was, I think 7, 8 years ago. As a glutton for punishment, I decided it's time to restart this conversation. In all seriousness, though, many states and also the federal government has become more involved in this issue. I think it's a perfect opportunity for an organization like NCOL to be a leader in this field. Following the discussion today, I look forward to working on a model law that I'll be bringing forth in the spring. Joining us today to discuss this issue are Maya Steinitz, Professor of Law at the Boston University School of Law. We have Jack Kelly, Managing Director of American Legal Finance Association. We have Mark Behrens, Co-Chair of the Public Policy Practice Group at Shook, Hardy, and Bacon. Eric Schuler, President of the Alliance for Responsible Consumer Legal Funding, and Jim Whittle, VP and Counsel at the American Property Casualty Insurance Association. To learn more about these speakers, you'll find their bios in the program and also on the app. I also urge you to reach out to them. Their contact information is there to learn more about them and these important issues. For the format, we'll start with letting them present their presentation, and then we'll go to questions once all the panelists have finished speaking. So let's go ahead and get started. And we're going to go, I believe, in this order, if we can, and that is we're going to start, Professor, with you, and then we'll move from Professor Steinitz to Jack Kelly, from Jack Kelly to Mark Behrens, from Mark Behrens to Eric Schuler, and from Eric Schuler to Jim Whittle. And there's no rhyme or reason to that order, other than that's what's on the paper. So with that, Professor Steinitz, I'll turn it over to you to begin your presentation.
Thank you very much, and thank you for having me here today to talk about this very important topic. I'm going to cover 3 things. First is what type of litigation finance exists. The second is who are the affected stakeholders, and very briefly, how are they affected? And finally, what are some regulatory models and approaches that are emerging? So with that overview, first, what kind of litigation finance do we have? We often hear the distinction between consumer funding and commercial funding. That distinction is somewhat helpful, but not as helpful as the extent of its usage may suggest. Consumer funding is small cases, personal injuries, and so forth. And those are certainly cases where the consumers may need consumer protection in a way that sophisticated parties like corporations don't necessarily need. But overall, most of the issues that litigation funding gives rise to is actually common to consumer and commercial funding. So I think it's more helpful to talk about the types of financial arrangements and products that are available. And I've listed them here in the order in which they evolved, but I want to emphasize that all of them exist simultaneously and will probably continue existing simultaneously. So we started first by saying single case funding, and that's a funder contracting directly with a client and funding a single case. That has evolved in the last decade, a little less than that I would say, into portfolio funding where multiple cases are being pulled together and the financing is provided via the law firm based on the pool of cases. And many people regard that, myself included, as a form of not just litigation finance, but law firm finance. Since in every state except Arizona, funders can't fund and buy equity in law firms directly. They invest in their inventory of cases, if you will. And again, I put law firm finance up there, A, because that's the way that portfolio litigation funding functions often, and also because it has created a discussion in at least one state, arguably more than one, maybe Nevada as well, a change towards allowing limited forms of investment in law firms themselves with a lot of regulation. And in brackets, I put up there secondary trading and securitization, and that is creating financial derivatives that are tied to the pools of funding. It's not clear how much that's happening yet, which is why it's in brackets. But that's, if you guys remember the mortgage-backed securities, where lots of mortgages were pulled and derivatives were created backed by that pool of asset, that's something that there's an interest in developing. And that should be on people's radars as well. Who are the affected stakeholders? One is plaintiffs. And the way they're affected includes the amount that they're paying for the financing, which in some cases is excessive. And they're affected because they have co-venturers. They have the funders as their co-venturers in the venture that is a lawsuit. And those co-venturers may have different interests than the plaintiffs. And the attorneys are getting paid by someone else, not by them. And so there's now structural conflicts of interest between the clients and their lawyers and between the clients and the funders. And that's changing the entire landscape of litigation. Defendants are another affected stakeholder. In cases where there's different scenarios that can come up in the Q&A where the funding creates due process problems for defendants, and that's where there's, in my view, a legitimate need for disclosure of the funding. And also, as there's more funding for cases, there's potentially more litigation, both of the meritorious kind, potentially also of the non-meritorious kind. So case volumes is a way that defendants are being affected, especially when there's portfolios of cases and a lot of cases are grouped together, some of which may be meritorious and some of which may not be. The court and the public are affected because litigation funding is reshaping both one of the three branches of government, the judiciary, the civil justice system, and it's reshaping the entire legal profession. And finally, investors are another stakeholders, people or entities who invest in litigation funding firms. They're investing in assets that are very hard to price and that have potentially very volatile pricing, where the information about the asset that they're investing in, which is a single case or a portfolio of cases, that information is partly protected by the attorney-client privilege, so it's hard to know exactly what the nature of the asset is and how it's changing, and in an asset that is currently unregulated. So those are the stakeholders, and very brief bullets, the way they're affected. And there could be, and there are law review articles on each and every single one of these bullet points. So it's a big universe of considerations. Finally, regulatory models or prongs to litigation. I'll mention briefly that other countries are ahead of us. The UK and Australia have had litigation funding for 30 years easily now, and they've experimented with regulation. Closer to home, Arizona in 2021 became, again, the first state to legalize investment in law firms directly, and they did that together with, in tandem with imposing essentially the entire code of legal ethics onto whoever is investing in a law firm in order to ensure that the conflicts of interest between funders and their clients are addressed. And the European Union is very actively working towards regulation of third-party funding. And very recently, the EU Parliament proposed a directive, which if it passes would mean that the member states would have to follow the directive, and they laid out how they think the industry should be funded throughout Europe. So some of the pillars that are emerging for regulation, as you'll see, it's actually a much broader scope than the way it's mostly discussed in the US. Here in the US, we talk mostly about whether and to what extent litigation funding agreements should be disclosed to the defendants. But there's actually much more that needs to be done once you understand who are all of the stakeholders and what's the universe of issues that litigation funding introduces, together with its benefits of providing access to justice, of course. So here are the pillars of the cutting-edge regulatory approaches. One is imposing fiduciary duties on the funders so that they would have the same kind of obligations to act in the best interest of the client that lawyers and insurers have. So we have third parties who have been allowed to finance other people's lawsuits for more than a century, and that's contingency fee lawyering and insurance companies, but it comes with fiduciary duties to the clients. Additional ethical requirements beyond fiduciary duties, explicit limitation on control of the litigation, whether it's direct or indirect, to ensure that the plaintiffs continue to control their case, because legal litigation is about the legal rights of plaintiffs and the legal obligations of defendants. So it should be plaintiffs who remain in control of their cases. Minimum return requirements. The EU, for example, their directive suggests that there would be a required 60% return of the gross settlement or damages that simply must go to the plaintiffs. And here I want to pause and say that minimum returns is different than a cap on fees and costs. Even though they sound like they're the same thing, we can just impose a cap and that means that there would be a minimum return. There's very little empirical research in this area, but the little empirical research that we do have indicates that fee caps can be worked around versus just saying here's a minimum that just has to go to the plaintiff. That can't be worked around, and that ensures that plaintiffs actually get a return or get at least a portion of the damages. Disclosure of the relationships of the funders that may be affecting conflicts of interest. So are the funders, do they regularly fund this lawsuit, this law firm? Do they have a repeat ongoing relationship with your lawyers? It may be something that the plaintiffs need to know, and it may be something that the defendant and the public and the judge needs to know. A duty to fund is an interesting thing that's included in the EU directive. And that's for the insurers in the room, insurance companies that would be familiar. That's the idea that if you are committing to provide funding to plaintiffs, then you need to actually not pull out in the middle of the litigation and leave the plaintiff hanging or use it as leverage over the plaintiff in order to control their case. Disclosure of the funding agreement, that's at the heart of the discussion again here in the US, is whether there should be disclosure of the funding arrangements to defendants. If so, when, how much disclosure, and so forth. Capitalization requirements, that's the idea that if you're going to be a funder in this space, you need to have a minimum amount of capitalization so that you can meet your obligations, and designation of enforcement authorities and establishment of a complaint mechanism. That's what Arizona has done, and that's what the EU is recommending as well. So with that, I think I yield the remainder of my time, and there's a slide here with some of the most recent works I've done in this area in case anybody wants to read some more. And of course, I welcome questions, whether it's today or you can always email me at Boston University. Thank you very much.
All right, thank you, Professor. And like I said, we'll hold for questions to the end. So next we have Jack Kelly. Jack.
Thank you, Mr. Past President Lehman. I appreciate you, and I also appreciate the members of this committee at 8 a.m. in the morning, even on a bright day at the Horseshoe, getting ready to go see some football. Can come over to Indiana and see one of the other teams, like the good chairman knows. In Indiana, we produce pretty good football. Chair and members of the committee, I would like to thank you for the opportunity to appear this morning. My name is Jack Kelly, and I'm here on behalf of the American Legal Finance Association, ALFA, which is the oldest consumer litigation funding trade association consisting of 40 leading companies in the market. The cornerstone of ALFA's guiding principles is transactional transparency. As you know, I'm a longtime NCOIL attendee and participant. 10 years ago, ALFA proactively sought NCOIL's adoption of Senator Breslin's model legislation to address oversight and regulation of this funding process. Regrettably, a model act was not adopted. However, I note that following those deliberations, NCOIL members returned to their home states and adopted legislation based upon the format of that model. I specifically would like to thank the past president from Indiana for his leadership. He left here and instantly went next door and passed the bill over a period of time. Another member of this body from a more progressive state, Vermont, left this body and went and passed their model. Allow me to take some time to discuss the differences between commercial and consumer litigation funding. As my colleague from Boston University said, more often than not, commercial and consumer litigation funding are conflated. They create a significant confusion in the development of public policy to address these competing and distinct products. Commercial litigation funding is a product that is used to fund the prosecution of litigation. It funds the actual cost of the litigation, including the attorney fees, cost of discovery, research, deposition, witness fees, and marketing, and other court costs associated with the pursuit of the legal claim. Commercial litigation funders often include private equity and large investment funds that become involved in litigation before the legal action is filed and even initiated. Commercial funding in many cases involves millions upon millions of dollars, in effect investing in the pursuit of the litigation. These investment funds have numerous analysts and legal professionals to determine the value of the investment in these large multi-million-dollar complex disputes involving intellectual property, bankruptcy, securities derivatives, and antitrust. This type of litigation often involves multi-jurisdictions across the globe and hundreds of millions of dollars in settlements and judgments. Commercial litigation funding is distinctly different from the transactions that members of ALFA provide. ALFA members provide consumer litigation funding. This is a transaction where a small amount of money, $3,000, $5,000, is provided to plaintiffs to assist them with their personal life needs during the pursuit of litigation. Consumer litigation funding only occurs after the plaintiff has filed a case. The case is already filed, its docket is set, and could be months after its initial filing. Therefore, consumer litigation funding has nothing to do with the initiation of litigation. While pursuing an personal injury claim, life needs are needed. People need to fund their rent, car payments, mortgages, groceries, and other personal needs. Consumer legal funding, litigation funding, do not provide funds to prosecute the litigation. It's critical for the committee to know that the funds provided by Alpha members are contractually prohibited from that plaintiff using them for court costs, fees, or expenses related to the prosecution. Imagine you're an Uber driver and you have a car accident, and it's 6 or 7 months and you can't get your car repaired. We fund that $2,000 or $3,000 to get that done. That's life needs. That's not paying for the litigation. All Alpha members must adhere to this and all other industry standards established by our best practices. Our best practices say that we prohibit any funds from being used for the cost of litigation or attorney fees. We prohibit the funding company from being involved in any decisions related to the litigation. We prohibit funding companies from paying any referral fees or commissions. We prohibit funding companies from using false or misleading advertising, and we require attorneys to acknowledge the existence of funding. Since Alpha was founded in 2007, we have advocated for the adoption of laws requiring registration, licensure, reporting mandates, and specific contractual protections for consumers, outlining easy-to-read contracts written in the language of the person who's signing the contract that include bold and boxed 12-point type print notices to the consumer on their rights, including the right of rescission. The Alpha model contract provisions have been incorporated into law in Tennessee, Indiana, Nevada, Utah, Vermont, Missouri, and Oklahoma. As a trade association, Alpha has actively sought the enforcement of individuals and entities that violate those laws. In fact, Alpha, at the request of the Consumer Financial Protection Board and the New York Attorney General, filed amicus curiae briefs in support of their pursuit and enforcement authority of a bad apple known as RD Legal. We have filed numerous amicus curiae briefs from coast to coast supporting transparency and protection. In closing, the two products being discussed today are very different. They're different as night and day. Consumer litigation funds are used to provide small amounts of money to plaintiffs in the need of funds for their life needs. Most importantly, the funds they receive are not paid back unless they receive funds in their settlement. If they lose their case, they pay nothing back. It is a non-recourse transaction. On the other hand, commercial litigation funds are used to initiate and pursue litigation. Today, many states regulate consumer litigation funding to ensure transparency, to know who is doing business in their state, to prohibit certain practices, and provide regulators the ability to oversee such conduct. I am not aware of any regulatory scheme or regimen that oversees or regulates the commercial litigation funding market. You, as legislators and as the leaders of the insurance body around the United States, must determine if that is a regimen that you think you should extend to commercial transactions. I want to thank you again for the opportunity to be here, and I'm happy to answer any and all questions that you have.
All right, thank you, Mr. Kelly. We'll move on to Mark Behrens. Mr. Behrens?
Thank you, Representative. I'm sorry, I've got a cold this week, so
Couldn't-
I'm sitting that away from my friend.
Oh, sorry, Mark.
I was going to say, well, I think we do need a microphone. There we go.
So I think Jack made some very significant points, and I'm going to talk about commercial litigation funding. So just again, to really simplify, we've got two completely different financial products here. The consumer lawsuit loans, which are small amounts that go directly to consumers to help them with living expenses. And then what I'm going to talk about, which is commercial litigation funding. These are big hedge funds, in some cases foreign sovereign wealth funds, that are loaning millions and millions of dollars to law firms to pay for the television advertising you see on TV and changing the way civil justice is made it functions in America. So very different products. And I'm going to talk about that other type of funding, commercial litigation funding, that is typically, and to come at this, so I represent, my law firm represents civil defendants, corporate defendants in complex civil cases. Most of my clients are large companies of the type that are in the mass tort ads that you see on TV, and this is a very significant issue for those companies for the reasons I'll talk about. One of the reasons that commercial litigation funding is so attractive, particularly right now, is that it offers investors an opportunity to make money that's completely untied to what's going on in the economy. All right? Right now we're in a place where the economy is struggling. We have rampant inflation, businesses are struggling to grow, right? The legal market is flourishing. And so the economy could be tanking, but you can put money into lawsuits and get 20% or more return on your money. So this is some place where people that have literally billions, millions or billions of dollars to invest, they could put it in the stock market where they're afraid it may go down right now. They put it in the bond market, which if they raise interest rates will go down. You could put it in real estate, which is struggling right now because of high interest rates. Or you could put it into litigation and get really significant returns. That's why this market is so attractive to big money investors, okay? So to give you a bit of a background on how big this market has come, it basically came to the United States, like Maya said, about 10 years ago. The latest report out of Westfleet Advisors, which advises litigation funders, found about a year ago that there were roughly 44 different active commercial investors with about $15 billion in assets. $15 billion that they're putting into generating lawsuits in the United States. The US GAO, Government Accountability Office, looked at this and found that the number of funding, the money out there to fund lawsuits doubled between 2017 and 2021. And the best estimates are that in the next few years it will double again, and there will be roughly $30 billion, $28 billion available to influence how litigation is handled in the United States. So massive amounts of money flowing into this area. Why is it a concern for our clients? One is that it raises very serious ethical concerns for the lawyers that are involved, because a lawyer has an ethical duty to represent their client and to exercise independent judgment. That can be compromised when there's somebody else that's not a party to the litigation that's provided the money. What do we say, the golden rule, the person with the gold rules. And here, that can happen, that if you're getting money from a funder who says, no, you can't settle this case right now, or you can't settle this case for this amount of money because I've got a certain amount of return on investment I expect for the money I put into this case. What does a lawyer do in that situation where it may be in the client's best interest to get some money, but it may be in the funder's interest to roll the dice to go for the jackpot verdict? Puts the lawyers in a bind. It generates speculative lawsuits. Now, the commercial litigation funding industry will say, we don't fund frivolous lawsuits. But there's a very big difference between a frivolous lawsuit and a speculative lawsuit. Many of these can be frivolous, but I'm just going to give you one example. Bayer in the Roundup litigation you see on TV. Roundup is a product that's been in the marketplace for 50 years. It's probably one of the more studied chemicals in the history of EPA. It is approved as safe worldwide by every regulatory agency in the world. None of them believe that it causes cancer. Bayer won 9 verdicts in a row. In the last 3 weeks, they lost a verdict in Philadelphia for $175 million and one in San Diego for about $330 million. So if you're a funder, you can lose 9 cases in a row if you're going to win 2 cases that together are over $500 million. That's what this money is going to. It's gambling. It's gambling. It's betting on the American litigation And it's betting that even if we if we lose 10 cases in a row, if we win one in a big way, that will pay for our investment and we can keep going. And so it does generate speculative lawsuits. It prolongs litigation and increases settlement. That's only obvious. You've got somebody else in the mix that has to get paid now. It's not just about making sure the plaintiff lawyer gets paid and the plaintiff gets paid. Now you've got this outside investor that wants to get paid. I was at a program on Monday at George Mason Law School with one of the funders, and he was asked, well, what kind of return on investment do your investors expect? And he said they expect a minimum return of 20%. So very hefty returns. They're making a lot of money in this area. Obviously, if the investor is going to get a 20% return on their investment, that gets baked into the cost of the lawsuit, the settlement, and it raises settlement costs and frustrates. And then a newer issue that we're hearing more concern about that Congress is looking at is the ability for foreign sovereign wealth funds. These would be like Russian oligarchs or Russian money, Chinese money, that again, they're looking to invest. Abu Dhabi, Saudi Arabia, people with billions of dollars to invest. And again, they're doing the same calculate. They're investors. They're saying the stock market doesn't look great right now. The bond market doesn't look good right now. Where can we park our money? Real estate looks bad. Let's park it in the U.S. lawsuit system. But it could be destabilizing because, China could realize that we could pump billions of dollars into funding lawsuits in the United States and make American businesses less competitive. This is a cost on American business. And China can influence the competitiveness of U.S. businesses by putting money into our lawsuit system. So, and I'll just close with one last point, because you'll hear funders say, well, we provide a social benefit. We allow David to take on Goliath. We allow the injured person to take on a big pharmaceutical company or a big automotive company or a big chemical company. We've had lawsuits in America since George Washington. We've had really big lawsuits in America in the last 25 years. The mass tort environment found funding before there was third-party investors, and they found it through normal bank loans. So this idea that we have to have this to level the playing field is just BS. There was a way to level the playing field that's always existed in the United States. And this money, if it was only going to fund the plaintiff's fee or to fund expert witness cost and travel costs and things like that, maybe then you could make the argument, this is about leveling the playing field. That's not where this money is going, and why it is so dangerous. As Maya said, this is not just money that's going to fund litigation. It is money that is changing the entire ecosystem in which litigation occurs in the United States. It's paying for the TV ads you see running all day on TV. Most of those are not even done by law firms. They're done by what's called lead generators that are non-lawyers that are simply trying to recruit claimants, some of whom may never have used the product that's at issue and may not have the injury that's at issue, okay? These are companies that make their money by coming up with lists of names that they sell to law firms who then file lawsuits without doing any vetting as to whether those claimants actually have legitimate claims. And the idea is to flood the system with thousands of lawsuits, overwhelm the courts, and force defendants into mass settlements. That's what this is all about. It's not just about funding litigation. It is about changing the ecosystem of our litigation environment to generate mass litigation and force mass settlements. And, we're not looking, I represent, companies I work with and include groups like the U.S. Chamber Institute for Legal Reform, and there's no call on our side to ban this practice. I think most of my clients would love to ban it. But the only thing that they're asking for right now is just simple disclosure, to say that the judge and the litigants ought to know if there is some party that's a puppeteer in the background that's pulling the strings of litigation. Because if we go into a room to settle and the judge goes into a room to settle, you want to be able to know that you're dealing with somebody that's got settlement authority. You don't want to work out what you think is a settlement and then have them say, oh, I need to go make a phone call now to get clearance from somebody that you never knew was involved in this lawsuit. It's to get them at the table and to get, all the cards out so that we have transparency, and that's the only thing that we're seeking on our side at this point. And I'd be happy to answer any questions later. Thank you.
All right, thank you, Mr. Burns. Eric Schuler, you're up.
Thank you, Representative, and thank NQUEL for inviting me to participate in this. My name is Eric Schuler, and I represent the Alliance for Responsible Consumer Legal Funding. Like Jack's organization, we represent funding companies that offer this product on the consumer side. One of the things I just want to make sure that we emphasize on our end is that the average funding we provide a consumer, as Jack said, is $2,000 to $5,000. On the commercial side, the minimums are typically about $2 million. It's just a couple of zeros difference, or in government accounting, a rounding error difference. These are clearly distinctly different products. The funds that are used to, on the litigation financing side, as was stated before, are used to bring the case forward. We're ensuring that a consumer can keep a roof over their head, food on the table, and keep the lights on while their case is making its way through the legal system. Our product is, there's a saying that insurance is designed to make you whole and not designed to make you rich. We're just trying to get that consumer as whole as possible. We're just trying to make sure they get the full value of their claim and not have to settle short just because they're in a financial straits. Perfect example of that is we did a survey with our consumers, several hundred consumers across the country this year. We did it about 7 years ago as well. There's one thing that really stuck as a big difference to me was one of the questions that we asked the consumers was, what did you do for money before you got legal funding? About 7 years ago, the response was short-term loans, payday, things like that. The other question was, were you working at the time in which you got legal funding? Majority of the time back then it was yes. This year the response is, we got money from friends and family. And were you working? And the answer was no. And the follow-up question was it a result in which led you to bring your lawsuit forward? And the answer was yes. People don't have the resources they can go out to get short-term loans or sometimes, payday or car title because the fact of a lot of times the people are using our product aren't working. They don't have those resources. Financial institutions that are federally chartered are basically are prohibited from offering this type of a product to the consumer because under the Dodd-Frank Act, they have to have the ability to repay. If the consumer isn't working, they has no source of income, they don't have that. We don't look at those things. A lot of times people like to say, well, you're just another loan. We're not loans. In fact, the courts have said that we're not loans. And recently in Minnesota, they said that. We don't have any of the characteristics of a loan. A loan has a guaranteed some certainty of repayment, meaning that if I give you $1 today, no matter what happens, I'm expecting my dollar back. And if I don't get my dollar back, I can come after you. I can ding your credit. I can sue you. I can garnish your wages. I can do something negative to you. In our situation, if the case doesn't come to a positive outcome or there's not enough money to meet the obligation after everything's paid, we can't go after the consumer. Even in the rare instance, and it does happen, the consumer drops the claim along the way and says, hey, I can't deal with this anymore. I've got another job offer in Florida. I'm moving down. We can't go after them. As long as at the time in which we provide the funding, there was no fraud involved, there's nothing we can do to go after that consumer. We don't look at their credit. We don't look at their job history. We don't look at how much money they have in the bank. We don't look at whether or not they have another source of income. None of those situations come into play when we look at whether or not we're going to provide funding to a consumer. We're looking at their case, and is there a good probability that they're going to be successful in their case? That's it. One of the things that we're clear about, and I know Jack's organization is as well, is that the consumer knows exactly what they're getting themselves into. We have also worked in setting up a best practice. We work with the American Bar Association on that. We want to know that, make sure the consumer knows exactly what it is they're getting themselves into, that they know exactly what the cost of the product is. There are no hidden fees, no hidden transactions. But more importantly is that we stated in the statutes that we've passed and in our contracts that the funding company has no say in the settlement process. They cannot insert themselves into the case. They cannot call the consumer up and say, well, I understand you have an offer, that's not enough, you have to hold out for longer. Or I'm short of money this week, you need to settle your case. They can't do that. One of the things that's important that we've done in statutes, and with Representative Lehman's help, we did that in Indiana as well, I think it's important is the attorney-client privilege extend to the funding companies. That's important because we need to have an honest discussion with the attorney in this case as to whether and what the validities of these cases are. And even with that, I did a survey recently with our members, and it's interesting, post-COVID, the losses are greater than they were pre-COVID. Losses now for most of our companies that get less than contracted amount is about 30 to 35%. And now about 10% of the time they're getting absolutely zero back. So this is not a situation where these are guaranteed. I think it was done, the 60 Minutes piece that Professor Science participated in, the CEO of Burford said their loss rate is less than 2%. Unfortunately, we don't have that luxury. They look at these cases inside and out. And when they make decisions, and I would too if I'm putting millions of dollars into a case, look at it 6 ways. Most of the time, our companies can make a response to a consumer within about 24 to 48 hours. We just want to make sure this is a valid case, it's a valid claim, and that the consumer has a good opportunity to recoup on their case. One of the things I just want to cover quickly here is that sometimes people say that, oh, if you sanction this product, you're going to allow frivolous claims to hit the court systems. I was asked that question recently, and I tried to do some digging around in the courts in states in which we've passed statute, and luckily Ohio has some stats that are available. We've had a statute here in Ohio for about 15 years, and what was interesting about that, it was done in which there was a case that said that champerty was in place here in Ohio, and that statute that was passed here in Ohio, I believe unanimously from both the House and the Senate, allowed consumer legal funding to operate. Since that statute's been in place, there's been a 30% reduction in court filings. Now, am I saying consumer legal funding is a result of it? No, by no means. What I'm saying is it also did not increase the courts. And one thing I just want to finally say is if you have any questions on it, take a look at our websites. We've got a lot of information on there. We go through a lot of detail. We try and pride ourselves that there's a lot of information, a 101 on what the product is, but more importantly, what the product isn't. If you have any questions, I'd be happy to answer your questions now, or if you're free to drop me a line later on and help you out. Thank you. Appreciate your time.
All right, thank you, Eric. Our final panelist, Jim Whittle. Jim, you're up.
Thanks, Representative and legislators. I appreciate being here today to talk about this important topic. I am Jim Whittle, and I work with the American Property Casualty Insurance Association. You don't have to see Frank today because he decided you needed a break on Saturday before you pre-game for the Ohio State. So you get me instead as a result. I am pleased to say that when it comes to litigation financing, particularly the issue that I'm concerned about, it's disclosure and the potential for discovery into it in litigation. We now have a number of jurisdictions that have passed laws that require the disclosure when there's litigation funding. We have Montana, we have Indiana, we have West Virginia, and we have Wisconsin. So it is not something that is, and I imagine, actually, I should add, we're going to see more of those this year in particular and in years to come. And so it's not as if the idea of people investing in litigation, that's the important thing to think about. It's litigation funding. It's litigation financing. They're an interested party as a result. And I know there's a lot of talk about consumer versus commercial, and I appreciate those distinctions. It's sort of apples and oranges. But what I have to ask is, isn't it all just fruit? Because the reality is, if you're engaging in backing litigation and you have a financial stake in that, you're an interested party. And the civil justice system isn't a marketplace. It's about civil justice. And shouldn't we all know when interested parties are actively engaged in or backing a particular party in a case? Now, I represent the insurance industry, and I can proudly say that we have essentially unanimous, or should I say universal, disclosure obligations related to insurance and litigation. The civil rules of evidence provide for it, the state rules of evidence provide for it. And yet, my colleagues on either side of me, they will tell you, you don't need it when it comes to litigation financing. We're different. At the same token, I have heard, and it's been reported in some recent media, that some financiers have said at conferences, we're like insurance. I would welcome litigation financing being regulated like my industry. The scrutiny, the disclosure, the transparency would be incredible. We would learn so much, all of us here, everybody in America as a result. But that isn't the case, and we're not really here to talk about that. When I was here and I was prepared to speak with you, I thought about what I might say. I do think there's a need for transparency in litigation financing. It impacts the civil justice system. That's not an economy. That is our civil justice system. And it seems so straightforward to me. It's backing a civil claim. We should all know that. And then I thought about the example of the 9/11 first responder, and actually Jack mentioned this, it's already legal. That first responder was paying an effective annual interest rate of 250% on what was in essence a 3-month bridge loan. 250%. This is a person who went to the 9/11 site and was working, putting themselves at risk. That's shameful. I thought about the 30% of intellectual property in the U.S., intellectual property litigation in the U.S. that goes on now, that now has litigation finance backing. I'll provide you citations for everything I'm talking about. And on top of that, how the intellectual property, that could be disclosing the most sensitive business information a company has. It could be source code. And on top of that, now what we know is there's foreign investment in these cases as well. And not only is it foreign investment, it's foreign sovereign wealth investment. That is foreign nationals, and that's national governments. And if you look at the top 10 or so, they're all countries that we might think of as not necessarily adversaries, but our strongest competitors internationally. We need to know this is going on. I thought about the massive growth in litigation financing here in the U.S. I thought about the Government Accountability Office's conclusions recently, how little is known about litigation financing, how little disclosure there is for litigation financing. I thought about Cisco Corporation, a U.S. Fortune 100 company that was litigating with its own financier, claiming the financier was trying to control the litigation rather than Cisco. And that's contrary to the position that financier took on 60 Minutes, for example. And I thought about it, and I said, if a successful corporation like Cisco is having trouble with litigation financing, people might take notice, people might act, they might think about the smaller companies and the consumers that are being affected by it. And then finally, I just wanted to share a few quotes with you from a recent article in Bloomberg Law, and it's about the Camp Lejeune Mass Tort Fund. By the way, to Mark's point, that same article in Bloomberg reports that there's been $145 million in advertising just on the Camp Lejeune water case. $145 million worth of advertising. So as of mid-October, there's 117,000 claimants. And this, mind you, is a federal government program intended to help veterans, the military, their families, people who were hurt from consuming poisoned water. It's your tax dollars at work. It's all of our tax dollars at work. The payout could ultimately top $21 billion, it was reported. And I'm going to give you some quotes now. One mass tort lawyer, and this is from the article, I'll share the article, said their internal auditors determined hundreds of referrals from other lawyers for Camp Lejeune and other cases were bogus. They were often based on doctored medical records and fictional reports of disease or other sickness. And, I'm going to continue. These are all quotes. A surge in available litigation funding means extra resources for law firms to find and register as many potential plaintiffs as they can before the window to file claims ends. Lead generators typically, and again Mark referred to this, typically get paid up front for delivering potential clients, sometimes thousands of dollars for each name. These are not even people who've got a lawsuit yet. And the lead generators are getting thousands of dollars per name. The article continues, demand for their services has grown in part because of a surge in litigation funding. Our civil justice system, litigation funding. One consultant told Bloomberg Law that lenders by mid-year had committed nearly $2 billion, this is litigation funding, $2 billion to firms filing Camp Lejeune lawsuits, $2 billion just for Camp Lejeune. Industry veterans understand, and this is a quote from the veteran, the industry veteran, an influx of capital invites greed, said Brian Roth, CEO of Rochade Capital, a litigation funding firm. The key to preventing fraud in the industry, he said, is understanding the roles and backgrounds of all the parties. This I agree with. We need to understand they're out there, what cases they're involved in. Disclosure is simple. We're not even trying to ban it, as Mark said, because our clients also might like to see that happen, but they're not pushing for that. They're saying, let's all just know who's involved. So anyhow, I've shared a lot, and I really want to thank you all, because I think this is an important examination. It's incredibly timely, and I think action to disclose this activity is important to the integrity of the civil justice system. So I'm happy to answer any questions, and I look forward to working with NCOIL as you advance your legislation.
All right, thank you, Jim, and thank you to all the panel. You've given us a lot to unpack. And I'll start with my unpacking. Just a couple of thoughts. One is, and I've never been accused of having a brilliant legal mind. I'm not an attorney. But in all my years of insurance, we teach our new producers one thing: negligence equals loss. I mean, you have to have a proof of negligence before there's a financial loss to have a payment, right? But interesting, I think Mr. Barron just brought up the Roundup case in San Diego. I found this very interesting. This is a Forbes article. It said, despite this substantial verdict, which was $332 million, the jury actually found partially in Bayer's favor. The jury found that Bayer failed to provide warnings of Roundup's risk, but did not find that Roundup was defective or that the company was negligent. So basically, a $332 million claim was paid and there was no negligence? There's a disconnect there for me. Okay, so I struggle with a little bit of that. So now I go down this path. I heard Professor talk about reshaping our judicial system. You talked about investment opportunities. We've heard about these investment opportunities. So my question is this. I think there are two issues and two paths. One issue, the first issue being commercial versus consumer. The second issue being regulate or prohibit. So I've heard those opposed to this mechanism to say, we're really not here to ask for a prohibition. Now, granted, there are some who would like that. So we heard from the professor that in the EU there's these pillars, and I pulled these pillars up. So I guess my question to the panel would be is if we begin, as we will, begin to pursue some path on this, if we look at it from a regulatory, just a pure regulatory standpoint, if you were to implement the pillars, which really are pretty much ethical guidelines and directing the money to where it is supposed to be, disclosure, transparency. If we do that, if we were to put the only ban being a ban on foreign investment, I think everybody kind of has a problem with that piece of foreign companies profiting from our judicial system. Just that statement alone, makes my hair stand up. And then in that vein of transparency is just very broad and big disclosure. So I guess to the panel is, if that's where we begin to go, are we on the right path?
May I, Mr. Chairman? I think that the right path is that we need to have oversight and regulation of this marketplace. And there's two different marketplaces. And that's the important thing. There are two different marketplaces, and the oversight has to be much different. For the consumer side, it's important, A, that the companies be registered, they be licensed, that they have to report who they are, that you have to disclose when you file for your registration or your licensure who owns you. Who's the owners? Who are the officers? Are these people that you want to be doing business in your state? It has to have a complaint portal for the state so that when somebody knows, a consumer knows, a regular Joe can go on and go find out. And then annually make sure they report to the state, and it gets published, how many transactions they did, their average rate for fees, so that people know exactly what's going on in the state. That's important. Today, we do that in the consumer side, thanks to legislation like Mr. Lehrman's. But the commercial side has no oversight. If you look at any bill that's been passed on this legislation, it says does not apply to someone who funds over $500,000. Having spent many years drafting legislation, the one thing I know, that's a comma I would love to have in my law. Because we fund little guys. We don't fund $500,000. We fund $2,000, $3,000. But if you fund 500, think of that big number. You suddenly don't have to report, you don't have to register, and you don't have to tell anybody who you are. That, Mr. Chairman, is the crux of where we need to get to on this legislation.
I'll try to answer much more simply by saying, in response directly to your question, yes. I believe that if you provide, as you've described it, necessary disclosure in litigation for all litigation funding, that would be a major step forward for transparency, for the needs of a civil justice system. And I also agree with the idea and the concept that sovereign wealth fund investment in the U.S. civil justice system is a mistake. I will add that there are some other disclosures that are important that have become part of the law around the country related to the consumer that are important for consumer protections. I think those need to continue. And I think it needs to be expressly stated in your laws, because notwithstanding these gentlemen and their self-regulatory enterprises, there are people out there who are not members of their organizations who are still misbehaving, that there shouldn't be control of the litigation by a financier. That should be between the claimant and their attorney.
Framework for legislation for the commercial side on this. Three things that I'd look to put in there is disclosure, and that's really important. Again, for the courts to know who is involved, maybe in settlement. It's important to us as litigators to know, because you're doing a protective order in a case. Let's say that you're Coca-Cola and you're litigating something where somebody asks you for the formula to Coca-Cola. Typically, when you would produce that, you would do it under a protective order, right? Which says, I'll give you this formula for purposes of this litigation, but you can't share it with other people. But if there's a funder involved, we need to know that, because maybe that protective order now needs to be rewritten to not just cover the other party, but the funder that's behind them that may be looking at this. So that's a reason, like a real litigation reason why I need to know that when we're designing protective orders. So disclosure is one. The other one is to stop the foreign governments from funding lawsuits in the United States. Just ban the foreign funding of lawsuits. And at the federal level, there's some legislation that was introduced by Senator Joe Manchin and Senator Kennedy of Louisiana to do that. And it probably won't move at the federal level, but it's a template out there for dealing with this foreign issue. And then the other is to protect the consumer and the lawyer, frankly, by saying that the litigation decisions have to be made by the lawyer, who has the ethical obligation to the client. And the funder cannot control litigation decisions. They can't decide how the litigation is going to be pursued, when it's going to settle, for how much. Those are the lawyers. That's between the lawyer and the client. And it should be that if the funders are just simply paying for the litigation, they put up the money and they can't control it. And I think the legislation should make that clear as well.
I would echo or add two things. One is I like the metaphor, the idea that apples and oranges are both fruit. And to follow up on that, because I think that the distinction between consumer and commercial funding is overstated in terms of its usefulness, is just to say this: when you take a lot of small loans and you pull them into a single pool, a single portfolio, now you have one very large portfolio, and the financing of that portfolio looks a lot like the financing of large commercial claims. You tend to have similar players, because now we're talking about tens of millions of dollars or billions of dollars, and it creates the same conflicts of interests and misalignments of incentives and so forth. So that's one thing. The other thing is, if I were to choose one thing as a cornerstone, it would actually be fiduciary duties, so that funders have a duty to act in the best interest of the claimant and not in their own best interest. Because what's happening now is that we've always had clients and their lawyers, and their interests were more or less aligned, not 100%, but more or less aligned. Now we have this third party, which is the funders, and they're pulling the alignment, they're pulling the lawyers' interests more in line with them, because they're funding them repeatedly. So now the lawyer is structurally in a conflict of interest. And the way to realign the interest is to say, okay, the funder has to have the same kind of fiduciary duties that the attorney has, and now everybody's interests are aligned, because the legislation says to the funder, your interests have to be aligned with the client, and now therefore the lawyer is not caught in between the clients that they have obligation towards and the people who are paying their fees in this case and maybe paying their fees in future cases as well.
May just kind of wrap up. Our organization, we're not opposed to regulation. When I know NCOIL looked at this, I think it was about a decade ago, there were probably 2 states that had something on the books on it. Since then, there are about a dozen states now. So I'm not, from a practicality standpoint, not sure if that's something that the organization needs to look at. Just look at what's passed. Look at what's passed in Indiana. Look what's passed in Vermont, Missouri, Utah. If you look at the basic structures of all of those statutes, they pretty much have everything that's been discussed here, that the funding companies cannot have a say in the settlement process. That one of the things also too we have in there, that there can be no attorney ownership in a funding company. So an attorney that's representing their client cannot have a financial interest in a funding company. And so I think those items are already covered in the statutes that we already have out there. But I think what's very clear is that this organization, one of the things that I kind of pulled up, NCOIL discussion topic suggestions from John Zilmer from Zurich on this topic, but what he wants to talk about is portfolio funding. I think you need to look at those situations, look at the litigation financing, the financing of the claims themselves, the portfolio financing. Those are situations in which, as was stated, has some potential of having a real impact on the legal system. giving a few $1,000s to a consumer, to be honest with you, is not having a real impact on the legal system. I got into a discussion with somebody recently saying that, us giving money to a client leads to nuclear verdicts. I was point blank with them. I says, I'm sorry, if one of my companies gives someone $3,000 and that ends up to be a $10 million verdict, you've got bad lawyers on your side. It just doesn't happen. Giving a consumer a few $1,000s does not lead to nuclear verdicts. It just makes sure that they can keep a roof over their head, food on the table, and see themselves through the legal process. Thank you.
All right, thank you. We have several members who have questions. If you have questions, we'll try to get to everybody here. We'll start with Representative Jordan.
Thank you, Mr. Chair. Look, I've heard some things, but I'm not sure. For disclosure, I'm a plaintiff's attorney. I've litigated lots of cases, and let me say this: I'm not necessarily a fan of litigation financing, but if clients want to use it, that's their choice. But I heard some things today that I thought, at least I should address. We're talking about this compromising of lawyers. I've never met one lawyer that's been compromised by litigation funding. If they have been, then I think the state disciplinary councils can deal with that. I don't know if any lawyer has been disbarred or suspended in dealing with litigation funding. I'm not saying it doesn't occur, but we have mechanisms in place for that. The advertising, I don't like that either. But the Supreme Court has said that we have a First Amendment right to advertise. So we can't get around that. So whether it's the Camp Lejeune, whether it's the plaintiff, the personal injury attorney that you see on TV, Supreme Court has addressed that in most every state. But as it relates to the litigation funding, one of the biggest things I guess I have a problem with is this disclosure of funding in litigation. And I heard the gentleman talk about the litigation funders being interested parties. They're really not interested parties. If they were interested parties, in most states they would have a right to intervene in a suit. These people do not have a right to intervene in a suit. They're no different than if you got money from your mother or your brother or some family member that you'd have to disclose that. I mean, to me that, I'll be respectful, but I would just tell you it has nothing to do with that other than to disclose to say that you have an adverse inference. There's no reason to disclose it because it has nothing to do with the merits of the case. So for instance, let's say that somebody was funded by Oasis and say Oasis gave them, let's just use $20,000. To disclose that to a judge or a jury really has no merit to whether they were injured by the defendant. It really is just there to create an adverse inference to say that this party is funding it, so therefore something must be amiss. The other issue is, though, when we're talking about settling these cases, if you disclose that, then that creates leverage for the other side. Because the assumption is if you're using litigation funding, then you probably are having financial difficulties. And if you're having financial difficulties, you're probably more inclined to take a lesser amount than you may actually be due. And so that, to me, that's where all this comes from, is defendants want to know what your situation is to give them leverage in negotiations. I think if you want to, I think somebody made a great point, if you don't want foreign investment in these companies, I think that's great. I think if they want to be registered with the Department of Insurance or the Office of Financial Institutions, I think that's great. I think to the professor's point, if you want to have, whether it be fee caps or minimum returns, and you put some type of regulations about that, I would support that. But some of these other issues I've heard, where we're taking these extreme anecdotal situations and trying to make that the norm, I can tell you for somebody that's been litigating for 25 years, I just have not seen some of that. I'm not telling you that it doesn't occur, but I would tell you that that would be the exception rather than the rule. But I would certainly be vehemently against the disclosure in litigation. I really think that that would lead, we're talking about access to justice and availability of the justice system, that would really create some issues that would not be favorable for the fair, I think, meeting of justice.
Thank you, Representative Jordan. I don't know that there was a question there, and that's fine, because I absolutely appreciate your comments and your thoughts, I do. I don't know if you want the panel to comment on.
They
on
can
some of
comment on anything I
that.
said.
If you want to kind of comment, is there anything you want to comment to on what he said, and then we have some other questions.
I actually was going to respond because I think it is a very important point he raises, and I've been an attorney for 33 years, and I was a trial lawyer, and I was actually class counsel in the matter as well in the U.S. District Court in New Jersey. So I appreciate the comment. I think the point we're trying to make with regard to disclosure may be we should have made it a little more thoroughly. I think the point there is disclosure to the parties, not necessarily to the jury, for example. And I think the point there is, and it's been studied, and Professor Steinitz may be more aware of the studies than I am, that the potential for bias and conflicts of interest, and also the potential for control by a financier over a litigation. And that's precisely what happened in Cisco in that case. They did ultimately resolve it, probably because the financier there decided there was bad press, and I'd rather get to yes, but that was an example of control that was trying to be exerted, according to the complaint there, against one of America's largest private, or should I say public corporations. But the point on disclosure is to the parties. There may be a potential for discovery because if, for example, you find bias or evidentiary value in that the financier is underwriting the costs for treatments that otherwise would not be ever used in a case, and there are examples of that from claims files from insurers, that may be more relevant, but then it becomes a question for the judge. The judge would be deciding the evidentiary value of the case. We're talking about disclosure to the parties. It may not ever be introduced into evidence.
All right, one more quick comment, and then we
quick
need to move on. We
comment.
got a lot of questions.
From the plaintiff's perspective, this has always been very interesting to me, because if I were a plaintiff's lawyer, the first thing I would want to do is disclose to the other side that I'm fully funded, that I'm not going to run out of money, that if I get a big verdict, I'm going to be able to go hire the best appellate lawyers to uphold it on appeal. And I've always questioned, why is the industry opposed to disclosure? Because I would think it's in the plaintiff's interest to have disclosure and let the other side know, you're not going to wear me down. Because doing defense work, I've seen plaintiffs that have gotten worn down 3-4 years into litigation that finally say, all right, I'll take a settlement because I just need some money, or the lawyer says I need some money. So I've always thought the lawyers would have an interest in telling me, hey, you're not going to wear me down. I'm fully funded. I'm going to run this thing all the way out. I got all the money in the world to do all the discovery that I need. And if I'm going to win, I'm going to get great lawyers that are going to uphold it on appeal. Because that would raise the value of that case in my perspective and raise the settlement value. So I've always questioned, why doesn't the other side want disclosure? Because you think it would be in their interest.
I think that's very simple. So again, let's go back to the thing. Apples and oranges, they're not, I mean, they're all fruit, but this is where you would have the distinction. I think if you're talking about somebody that's putting $20 million in a case, I might not necessarily disagree with you. I still wouldn't want disclosure of it, but I get your point. But I can tell you this, when you've got plaintiffs that are of limited means to begin with, and let's just use an auto accident, for example, and now they can't work, they may have had a minimum wage job, now they've gotten $20,000 from Oasis, I'm just going to use them, they're one of the litigation funders. Why would you want to disclose that? Because now that does create a leverage point for the defense to know that that person is in financial difficulties and maybe constraints. And that gives them an opportunity to lowball. So you might have a case that's worth $1 million, but you may offer them $300,000 because you know that they're in some financial trouble. They may take the 300 when the case is really worth more. And as an attorney, we have to listen. We advise our clients, but our clients are ultimately the ones who control the litigation and the amount that's settled for. And if they say they want to take the 300, even if I'm telling them it's worth $1 million, that's what you do. So that creates leverage points that I would not want to disclose as a plaintiff's attorney to any defendant.
All right, we need to move on. We got several names here that need to ask some questions, and we're going to run out of time, and I want everybody to have their voice. So we're going to move on to Representative Bennett for his question.
Thank you, Mr. Chairman. And thank you all. Full disclosure, because I'm not trying to hide anything. I forgot my nameplate. My name is Forrest Bennett from Oklahoma. This whole conversation is making me think of that John Grisham novel, Runaway Jury. I don't know if you remember it, but it's all about a tobacco case and the amount of money that goes into it. And this conversation has been fascinating. We're talking all about the funding and that angle. We're not really talking about the plaintiffs themselves and sort of the merits of these cases. And I find it interesting. We know that corporate interests are able to use their profits to buy what I call social capital. You can be an incredible corporate polluter, but you can also run a local campaign to encourage recycling, and all of a sudden in the minds of people locally, this is a good corporate citizen. They know what they're doing, and we don't have a whole lot of conversation about that, but now all of a sudden when we talk about people raising money to try to raise interest levels and awareness of certain class action lawsuits, for example, all of a sudden we are concerned. We're all of a sudden concerned about nuclear jury or nuclear verdicts, but we haven't talked at all about the intentionality behind knowing that you've got a bad case, but also knowing that as the defense you've got an endless pocket of money to continue to just prolong the justice system. I heard about integrity of the judicial system. I heard about leveling the playing field. I hear the concerns, but to my colleague from Louisiana's point, there is some clear lack of a fair playing field here, and so I'd be curious if you're skeptical of these financing campaigns. What is an alternative to leveling this playing field? How do we make sure that plaintiffs, I understand that there's concern about foreign investment in our judicial system and all of that, but it seems like sometimes an intentional red herring, with all due respect, to get away from the idea that there are people out there who are aggrieved and deserve to have their day in court, and I don't think that the founders of this country intended for the judicial system to be one that you're able to use only if you can afford it. So I'm curious what alternatives for leveling the playing field would look like in your view.
I've been on these panels now for almost 15 years, and I think one of the interesting points is that we used to talk about whether third-party funding should be banned, and that conversation seems to be over. I think everybody understands at a minimum that it's here to stay, but I think a lot of people share your views that, and I also believe that we have various ways of limiting litigation abuse, and whether or not someone has funding to bring a case shouldn't be one of the ways in which we, as a society, decide whether a lawsuit is brought or not. So I think the discussion is how do we balance the various interests that are at play. And I'd like to use this opportunity to say on disclosure that because there's actually points on both sides. Defendants have legitimate points of concern. I've been involved in cases as an expert witness where funding agreements were used for questionable payments for fact witnesses and where funders took control of the litigation. On the other hand, there's a clear access to justice interest in providing these fundings. And in an article that's on the slides that you have that's called Follow the Money ? I have suggested that what we should do is have a balancing test to leave the question of disclosure to judges, to balance the competing interests, because there are legitimate competing interests on both sides, and the interests vary depending on the type of litigation. A class action is different than an automobile accident, and an automobile accident is different than a business-to-business multi-billion-dollar disputes. They're very different. That's why the debate becomes so sometimes tricky to decide which side one is on. And so if anybody's interested, there's a full balancing test that I've offered with the various interests and that should be balanced. So that's a possible approach.
If I may just very briefly, I recognize there's time limits. It's a really important question what you're asking. And I think I need to explain sort of the insurance product a little bit. I've spent my life around them. We have defense and indemnity obligations, and they're separate and distinct, but they overlap, of course, in the context of litigation. If a third party is identifying that this is a good claim, they've underwritten that claim. Typically speaking, an insurer is going to say, there's an independent party that is backing a claimant in this case, and I will have a continuing defense obligation for as long as the matter proceeds. But I could resolve the matter now. I probably will resolve the matter to reduce the continuing defense obligation, which is separate and distinct from our indemnity obligation. So I think some of what happens here may be different when it's an insured versus an uninsured situation because of the nature of the insurance product. But there's a lot of insurance and it's covering a lot of things, but at the same token, we're not going to necessarily run out the clock. I hear that run out the clock a lot. In 33 years as a practicing lawyer and as a prior litigator, I never saw a meritorious claimant who did not get an attorney in a situation that warranted it. I never did. I never did. And I represented pro bono, indigent, as well as people who were not pro bono and indigent.
Representative Meredith.
Thank you, Mr. Chairman. I got two quick questions. First one for Jack. Jack, you mentioned the complaint portals that get set up in some of the states, the regulated states. So one, who oversees those complaint portals in the regulated states that there are? And are you seeing complaints being filed through those portals, or what kind of complaints are being filed?
No, and I appreciate that, Mr. Meredith. Indiana has a system, all the states I said, Vermont, Oklahoma, Utah, Nevada, since all these laws have been passed, literally a handful of complaints. And they're usually overseen by either the Secretary of State or by the Director of Business or Insurance, whoever the regulator may be. And once you know who is in the business and who's registered and licensed, that regulator can send you a notice and say, you've got a complaint. That's the problem. We don't know who is in this game. When they talked about that fireman that got 150, they spent 150%, we joined the CFPB. We joined the New York Attorney General and had hundreds of thousands of dollars of costs filed amicus to support their enforcement authority of them, because we need to know what people are doing.
My second question will be for either Mark or the professor. Obviously, we all in this group are very, very tied to the state-based regulation of insurance and know how important it is. But if we were to pass something in a state relating to banning foreign money being put into this marketplace, what's the likelihood that that would hold up in court in a state-by-state regulated manner of that versus a congressional change?
It's a Commerce Clause issue. It's a Commerce Clause issue, to go back to first year.
All right,
An
well-
action would be brought, an action would be brought pursuant to the Commerce Clause of the Constitution. To be very honest, anybody who is familiar with the recent challenges of the Commerce Clause, they haven't been very successful, to be very honest. But there would be question, because you couldn't find where the money was. If it's in a giant fund, how do you, we don't disagree with it, but we're just saying I think you'd have a big challenge.
All right, Senator Theus?
Thank you very much. I appreciate it. My first comment has to do with coming from a state, with all due respect to my colleague, coming from a state with no fault where some of our court systems, 98% of their docket is no fault. When you write a blank check, it's amazing how many people show up to receive some money. And so I have that concern with this, and my first question was going to be, well, why not ban it? And I think you've answered some of that, but do you have a favorite place to go? What has the best transparency requirements? Which state has the best limitations, the best regulation from your perception, if we were just to pick one?
I'd say Montana.
I would respectfully disagree with the gentleman. I would say this, having been in this business a long time, Montana was an experience. The regimen that Mr. Lehman put in is very good. It's specific to Indiana, but the framework is good. Nevada, Utah, Oklahoma, Vermont, Tennessee, all have the basic same framework, which is licensure, registration, know who it is, require you have to have specificity in the contract. Our contracts have big and bold boxed letters that tell you what your obligations are and tell you what you need to know to protect yourself. You need to let people know what they're entering into. And I think the gentleman from Louisiana will tell you, if somebody wants to do this, that's their prerogative, but let them know what they're doing. Don't hide the ball.
I just have to say that I don't disagree with some of those states having regulatory schemes. They're very nominal. If you're talking about some of the things we talked about today, disclosure and litigation, you have to go to one of the other states. And Montana has both the regulatory aspects and the disclosure aspects. The other states that have been mentioned are strictly regulatory, very light touch regulation that I believe was passed in order to enable the companies to avoid something the founders were concerned about, which was champerty and maintenance.
My last question has to do with what does the typical client look like that is in this space? Is it a class action lawsuit where someone goes home with $6? Or is it are they an individual that really do have a merit-based case? And
It's the apples and the oranges, which is what's interesting. So we talk about the people. In the cases that we fund, that's somebody who comes in to see a lawyer who's had an auto accident, who's had an personal injury. That lawyer knows them, they talk to them, they see them. The cases that they're talking about on the oranges side are large pieces of multi-state litigation involving thousands of plaintiffs who the attorney never, ever sees. The plaintiff never meets that attorney. They just fill out a box, sign an affidavit, and they're part of the action. We fund real people who are hurt, who need to pay bills. They fund people to file a case, to bring the case, to find the names of the 1,000 people to sign up. That's the difference, man.
If I may, real quick, I respectfully disagree on the Montana situation. And Montana really doesn't do very much, to be honest with you, because the crux of the Montana legislation is regulating a consumer who gets money to bring litigation forward. That rarely happens. The litigation financing are mainly business-orientated transactions. Consumers aren't going to a litigation financer and saying, hey, I need $5 million to bring a case forward. And as Jack said, look at the states at which we have passed it. We think they're very strong, very strict. And as was stated, There are no complaints, and the only complaints that I've heard that my companies get is one complaint. And that is because the funding company did not give me money for my case, or did not give me enough money for my case. I'm sorry, the case wasn't worth it, or it's not a good case.
All right, Senator Godolfo?
Thank you, Chairman. My question is for you, Mr. Kelly. You had mentioned that Alpha contracts are transparent. I know we're a little pressed for time, but can you briefly expand on that, the transparency provisions in Alpha contracts?
Yeah, so it was we worked with the CFPB on this, and it's based upon a mortgage contract where you have big, bold type, tells you right away what your obligations are. And then it lists by month or by 6 months the amount of money you would owe the entire time you'd have the contract. So just like with a mortgage, where you go down, you can see every month actually how much you'll pay, it's there. The most important thing is our contracts have to be in the language of the person reading it. That's really important, because when you're given a right to rescission on that contract in red bold type, you need to be able to understand what it's saying.
All right, Representative Pollitt.
Thank you, Mr. Chair. Just a quick question, and it's directed, I think, again to Mr. Kelly here. Does litigation funding get used to pay for litigation cost, attorney cost, court cost? Just wanted to kind of make sure everybody understood, especially for me. You know, I'm an insurance agent. This has been litigation education this morning, so I appreciate it.
Consumer litigation funding goes to the person to pay bills, to pay food, to pay rent, to pay their car get fixed. Commercial litigation funding funds the case. It pays for the lawyers, it pays for their discovery, it pays for their witnesses, it pays for travel, it pays for experts. That is the money that drives the case.
All right, are there further questions? That's what I had on my list. If you have questions and didn't raise your hand, because I've got more. No, I guess I would say this, and I'll allow all of you to kind of give us some closing remarks as we kind of move forward. But as I've taken copious notes here today, I think when I began this conversation, I said we'll be bringing some draft of a model to Nashville in April. What my takeaways are is I think I've heard that the focus needs to stay on the commercial. That seems to be the piece that has caused the most contentiousness when it comes to some of the data we're seeing. And just from the standpoint of a heavy regulation, I think Representative Jordan makes some good points on some things that maybe we don't want to regulate too far. At the same time, I think we all want to see, none of us like to see our judicial system become an investment portfolio. I think if our founders could look at what we've done and said, you know, you're allowing money to dictate verdicts on both sides of that spectrum. I think as Representative Bennett pointed out, I mean, I think they would be a little bit appalled by that. So I guess my takeaway is I am looking for input. You've given us a lot of information as a panel. I'll challenge those in the room. I know there's a lot of people who have a dog in this fight. I want you to reach out to NCOL staff, to Will, and to myself, and to Patrick and Tom. Members here, reach out with what your thoughts are, because I do want to try to find a path that we can all, you know, it's never going to be unanimous. I understand that, and you know, I've got the scars from 10 years ago, and if we have to relitigate that, we will. But I want to make sure we try to find a path that is good for all of our consumers, while not throwing the baby out with the bathwater. So with that, the panel, maybe have any closing remarks you want to make? If not, we'll move forward. And we do have a little bit of time, so I'm not cutting anybody off here.
Enjoy the game.
Go Irish.
I just want to note one observation here. In all my years in NCOL, I've been coming here for I think 14 years now. I think it's the first time someone asked a question that nobody on the panel gave an answer to. That's number one. And number two is asking a group of lawyers in front of you if they have anything closing remarks and no one said a word. So I think we have set some great precedent here. Is there any other business to come? We don't have, it's not a committee, I guess we're just going to adjourn.
I attribute that to the smell of bratwurst and a football game.
Is there a motion to adjourn? Second, all in favor say aye, we are adjourned. We will go pretty much quickly into, I know it's Saturday, we want to move through these things quickly, but we are going to get into the next committee here in just a few minutes.